topic of today's keynote presentation is very timely. Multiple offers are common under our present bizarre market conditions. And when you think about it, with multiple buyers, each with a buyer's agent, an anxious seller with future plans hanging in the balance, and their agent, it can be quite a tense crowd. And the goal is for all those people to come away from the multiple offer process feeling that they were treated fairly and with respect. And to help us make that happen, Gov Hutchinson, Assistant General Counsel with C.A.R., has zoomed in from Los Angeles to provide us with some important legal and practical tips. And please take notes to share with your clients before the multiple offer event gets underway. It's important to get them up to speed before the excitement happens. Gov Hutchinson has been with C.A.R. since 1985 and manages the Member Legal Services Program in Los Angeles, and he trains and supervises the C.A.R. legal hotline attorneys. He received his bachelor's degree in history from Princeton and his Juris Doctorate from University of Pennsylvania. Gov, share your wisdom.
Well, thank you, Richard. Thanks, everyone. Good to see you guys. Good morning. Wish it was in person. Although I must admit, it's a lot easier getting to an 8:30 meeting when I don't have to leave the house as opposed to driving. But still, I still wish I were there in person. Yeah, the legal hotline, it's been crazy in the last year. Can you believe it's been basically exactly a year since we started doing all this? And last year, to reflect your market, I think in March and April and May, it was very slow. Then it gradually picked up. Then the hotline, we had the busiest in 3 months in our history in September, October, November of last year. Usually a downtime, and usually the calls to the hotline reflect the market. So you guys were incredibly busy. This year, it seems to be a little bit more normalized in the sense that our calls, we had a typical January, a typical February, and then March is picking up like it always. I mean, it's busy. And yes, we do get many calls regarding this seller's market that we're in and the multiple offer situation we're going to talk about. It's funny if you think about it. How long have we been in this seller's market? Like 20 years? When's the last time we were in a buyer's market? I mean, I remember a buyer's market. This was a long time ago. So we're in a seller's market, but now we're in an intense seller's market, which triggers multiple offers. And we get these questions on the hotline all day long. And I just want to cover a few things, and please ask any questions you want on anything you want as we go. And at the end, either way you want to do it. I mean, the fundamentals, I think everybody knows, is when you get multiple offers, sellers can ignore them, accept them, or counter them. If you're going to counter more than one at a time, of course, you use the seller multiple counteroffer form, because if you counter more than one using the regular counteroffer form, you've created a race to see who comes back first, and there's always a disagreement about who came back first. So you try to use the multiple counteroffer form, and then when you send out multiple counters, even if multiple buyers respond to those, the seller doesn't have to pick the first one back, and they can recounter if they want. Seller basically holds all the cards in that situation. Another fundamental thing, of course, is sometimes, once you counter something, seller make a counter, then the buyer counters that, they don't get response, and the buyer says, okay, I'll just accept your original counter. Once you counter someone's offer or counter someone's counteroffer, you lose the right to go back and accept the original offer or the original counteroffer. I mean, those are fundamentals. So we see that happening, of course. So how do you handle these multiple offers? By the way, one thing on the buyer's side, I'm not sure everyone knows, but buyers, to survive in this market, will often make multiple offers themselves on different properties, right? Which is perfectly okay. But did you know legally, if you're a buyer and you're making more than one simultaneous offer, you actually have to disclose that to each seller. Say, hey, seller, by the way, I'm making other offers too. Actually, not the first one. You make the first offer, that's fine. But then you make a second or a third offer while the first one is still pending. You've got to disclose to seller number 2 and seller number 3, I've already made another offer. I think a lot of people don't know about that particular buyer obligation, unless the buyer intends to buy all of them, which would be kind of rare, right? Okay. So how do you handle these multiple offers? I mean, as Richard said, and we get the complaints all day on the hotline about just lack of communication. I mean, it's, first of all, you have an ethics requirement to treat your fellow realtors fairly and don't ignore their phone calls when they ask you what's going on with my offer, what's going on with, have you presented offers, what are your plans? I mean, open communications is actually an ethics requirement. And we hear this all day long. The other agent didn't return my calls. I don't know what's going on. Then all of a sudden, the property is sold and I didn't know this, blah, 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 blah. So just remember ethically, communications is required. Also remember, as a listing agent, you have a fiduciary duty to your seller. The fiduciary duty to the seller is to do what the seller really wants you to do. What does the seller usually want? They usually want to sell the property for as much as they can. And typically what that means is exposing the property as widely as possible and hearing all offers and not cutting off offers or limiting offers, or, the favorite thing is all offers will be presented next Thursday and then Wednesday it goes pending because you accepted an offer in the meantime. I mean, number one, yes, the seller ultimately can decide what they want to do. Sellers can say all offers will be looked at Saturday, and then they all of a sudden change their mind. They don't want to wait. They don't have to wait. Sellers don't have to be fair, but it's got to be the seller making that decision, not the listing agent. The listing agent has to try to be completely fair to everyone as possible, because that's typically in the seller's interest, unless the seller says otherwise. I'm tired of all these offers. Let's just take this one, or something like that. Then you get these preemptive offers, of course. I don't care if all offers are going to be presented on Saturday. Here's my offer on Thursday. This is what it is. This offer is only good for 3 hours. Take it or leave it. And that's a legitimate thing. And you talk to the seller about that. Do you want to take that? Do you want to leave your options open? And ultimately, it's the seller's decision. But you also have to remember your ethical obligation to disclose to other agents what's going on. As Richard said, that's what gets people upset, when people don't know what's going on. If they know what's going on, it's a lot better. And it's also generally in the seller's interest, which is your fiduciary duty, to make the property as exposed as much as possible, give everyone a chance. That's typically what the seller wants. Okay, quick question, Karen. Yeah, you don't have to, if you're making a backup offer and you're a backup position, no, you don't have to disclose that to subsequent sellers. But if you're making just you don't even know, you're just throwing out a bunch of offers there, hoping some of them gets accepted, you do have to disclose that before you're in a backup position. Other things we're seeing is we're getting question after question on the hotline about escalation clauses and also clauses regarding appraisals. What's an escalation clause? An escalation clause is, my offer is $10,000 more than the next best offer you get. Is that legal? It is legal, but you got to understand the rules. First of all, there's some risks of doing that. If you just say my offer is X more than the next best offer you get, if the seller doesn't get any other offers, then your offer is not valid because it's referencing other offers. Of course, that's probably not a problem in this market, that they're not going to get any other offers, but that's one issue. Another issue, of course, is my offer is, what if you get 2 offers? There are 2 different offers that each one says my offer is X amount more than the next best offer you get. Well, if you get more than one of those, they cancel each other out. Courts basically say, well, it's impossible to have 2 different offers, each one saying they're they are X amount more than the next best offer. So if you have more than one of those, neither one of those offers is enforceable. So that's a risk you run, right? So one thought is the court to put a cap on it. My offer is 10,000 more than the next best offer with a cap of whatever. The problem with that, of course, is you just told the seller how high your buyer is willing to go anyway. So there's no mystery there anymore about negotiation, because the buyer has pretty much disclosed that. You do want to think about, though, just the possibility of putting a floor in there. What if I say my offer is 500,000 or $10,000 more than the next best offer, whichever is higher? Well, that's going to be a legitimate offer, okay? And then you have to worry about that not being legitimate. Marie Sue, yeah, when there's a cap, they cancel each other out, which is another way of saying they're just not enforceable offers at all. And you don't want to ever write an unenforceable offer. So that's the risk of writing an offer that way without maybe putting a floor in there, a commitment. I'll pay 500,000 or 10,000 more than the next best offer. Well, that at least commits you. Then the question is, what if you get two offers? Each one is saying something like, my offer is 500,000 plus or 10,000 more the next best offer, with a cap or without a cap, whatever. In that case, if you get two of those, the courts look at that as saying, well, which one had they look at the floor. My offer is whatever that was, and that's what the offer is. Forget the escalation part, because there was more than one of those. That parts cancel each other out. So you just look at what the basic floor of the offer was. So you think about that too, okay? Other things we're totally noticing in this market, as I'm sure you are all experiencing, is the whole, appraisals not catching up to the increase in value. So, appraisals come in low. So people try to deal with that in their offers various ways. One way is they say, buyer agrees to pay 10,000 above the appraised value or something like that. We have learned from talking to people on the hotline that people mean different things when they say that. Sometimes they're trying to say to the seller, my offer is, I want you to reduce the purchase price. My offer is, the purchase price is, what I'm offering is 10,000 more than the appraised value. So I'm basically saying, if you accept this, you've got to reduce the purchase price to that amount. But sometimes that's not what they mean by that. Sometimes they just mean that my offer, which has an appraisal contingency, I'm modifying the appraisal contingency. So I can't use the appraisal contingency to get out of the property unless it appraises at less than 10,000 less than the value. So maybe that's what they mean by that. So we have found this on the hotline, that people aren't sure exactly what they mean when they put that language in there. So it's always a good idea to qualify that. But then, of course, there's the question of what appraisal? Whose appraisal are we talking about here? What if there's more than one appraisal? In other words, it sometimes takes a lawyer really to draft this type of addendum to make it very clear what the buyer means by that, and what are the consequences if various things happen, like whose appraisal are we talking about? Is this a reduction in the sales price? Is the buyer saying they will, sometimes buyers put something like that, they will cover the difference between the purchase price and the appraisal. If they say that, do they still have an appraisal contingency is a question. If they're saying that, so you have to make clear, yes, I still have an appraisal contingency, and I agree that I will pay the difference between the appraised value and the actual price. The best way is probably just to say the agreement is contingent upon a written appraisal by a licensed or certified appraiser at no less than 10,000 below the purchase price, something like that. Then if you want to go further, like the buyer is actually committing, and if it doesn't appraise, I'll pay more, I'm willing to pay more. It's just that there are things to think about. It almost really needs a lawyer to help. You can call the legal hotline, we can help you with it. But we just see these random, my offer is 10,000 more than the appraised value without saying anything else. And then you get into escrow when this happens and the buyer and seller disagree on what that means, and it causes problems. Speaking of Randy Freed, okay, let me look at your question here. Isn't the correct term in escalation that any offer is higher, not the next best offer? So a buyer comes in with 1.5 million, but the next best offer 1.5. Yes, a good question. I mean, the point is, are you saying that they're saying I'm offering you 1.5 million or 15,000 more than the next best offer, whichever is higher? I mean, what if you don't put whichever is higher or whichever is lower? Then it's a little bit unclear exactly what that means. So you try to be as clear as you can be with and also, by the way, in an escalation clause, please put something in there like seller must verify in writing within X hours that they actually do have another offer for X value. You want that to be clearly in your language, that the seller must verify this. But you're exactly right. If you just say I'm offering 1.5 million or 15,000 more than the appraised value, you got to clarify, and whichever is higher or whichever is lower or something like that. Yes, so Jan, yes, the buyer must be given proof of that. You have to put that in there, that language, okay. Once again, what if the acceleration clauses are for different amounts? Very good question. In other words, two different offers. One says mine's $10,000 more than the next best offer. The other one says, well, mine's 15,000 more than the next best offer. Do those two cancel each other out? We've seen courts actually do that, even though they're different amounts. Then you'd think the one that says 15,000 higher should win over the 10,000 more. We've just not seen that happening we've seen court cases where they say, well, they still cancel each other out because they both two escalation clauses cancel each other out. That's why I'm saying just be cautious about this. Okay. By the way, speaking of contingencies, we're seeing a lot of non-contingent offers, right? Which is obviously a risky thing to do. You make a non-contingent offer. Let's say you don't have an appraisal contingency and it doesn't appraise. Too bad for you. Your offer is still valid. The seller can accept it. And now you don't want to pay more than the appraised value, or you can't get financing for that. You don't have a contingency. You don't have an excuse to get out of the deal. Arguably, the seller could accept your offer. If you don't perform, keep your deposit, which could be a significant amount of money. So there's a significant risk, obviously, with non-contingent offers. But then, of course, people say, if I don't make a non-contingent offer, I have no hope of getting my offer accepted. That's the joy of the intense seller's market, or not. Another thing to keep in mind, though, is, okay, even if a buyer makes a non-contingent offer, that doesn't mean the buyer doesn't have a way out of the deal, unless the seller has unless they've not only made a non-contingent offer, but the buyer has also signed the important disclosure documents that I'll mention in a second before they sign the offer. So let's say you just write a normal offer, no contingencies, but then the seller provides the disclosures to the buyer after the buyer has signed the offer. I mean, normally the seller has 7 days after acceptance to provide the disclosures to the buyer's agent. So you just a normal situation, buyer writes an offer, non-contingent offer gets accepted, and then the seller provides the disclosures to the buyer's agent. And the disclosures that I'm talking about are the TDS, the lead paint form, the NHD report, and now the fourth one, the new home fire hardening disclosure. Those 4 things give the buyer a 5-day right of rescission upon receipt by their agent. TDS, lead paint if it's pre-78, NHD report, and the brand new home fire hardening disclosure form. So in that scenario, even though the buyer made a non-contingent offer, they still have 5 days after receipt of any of these 5 days after their agent receives any of these documents to walk away. So if the seller doesn't want the buyer to have that right, then the seller would have to make sure that these disclosures are received by the buyer, not the buyer's agent, by the buyer, and signed by the buyer, not their agent, signed by the buyer prior to the signature on the offer, on the non-contingent offer. Only then does the buyer have absolutely no right to get out of the deal without jeopardizing losing their deposit. In other words, even if you deliver it to the buyer's agent prior to the buyer signing the offer, not good enough. If you include the disclosures in a counter offer saying by accepting this counter, you are acknowledging receipt of these disclosures, you can do that, but that doesn't get rid of the 5-day right of rescission, because by definition, if you're including that in a counter offer, that means the buyer has already signed the offer. So the only way to get rid of the statutory 5-day right of rescission that buyers have regarding these disclosures is to make sure the buyer signs each of these 4 disclosures prior to the signature on the offer. A couple of you have asked about the seller property questionnaire. No, the seller property questionnaire does not trigger a 5-day right of rescission. That's a mandatory disclosure only because it's mandatory in the purchase contract. It's not a statutory disclosure, which is the TDS, NHD, lead paint, and the new fire hardening was. Very good question someone just asked. Yes, even if the buyer has signed all these disclosures first, if subsequent to that, once you're in escrow, a new issue comes up, a new disclosure that wasn't disclosed before, that's a material fact, then the buyer again has a new 5-day right of rescission. Some people always ask me, was it I thought it was a 3 to 5 day right of rescission. It's 3 days if the document is delivered in person. It's 5 days if the document is delivered electronically, since I don't think anybody delivers things in person anymore. That's why I say 5 days, okay? But, and by the way, I think you all know this. Let's say the buyer has a non-contingent offer. Unless you counter it out, the buyer still has the right to inspect the property. They just don't have the right to complain if they find something they don't like. So the buyer, non-contingent offer, they get all their disclosures up front. They do exercise their right to do an inspection. The inspector finds this big problem that no one is aware of before. Does that give the buyer a rescission right? It doesn't, unless it can be proven that the seller was aware of and was hiding this issue that the inspector discovered. But if the inspector legitimately discovered something that the seller wasn't aware of, and you don't have an inspection contingency, and your rights of rescission are over, too bad for you, buyer. You still got to buy the house, or perhaps forfeit your deposit. Couple questions here. What about, does the listing agent's avid, is that part of the mandatory TDS? And that all depends on if on the 3rd page of the TDS, that box was checked, you know, C incorporated, the listing agent's basically saying, checking the box saying their avid is part of the TDS. If that box is checked, then yes, the avid is part of the TDS. And if the avid doesn't come in till late, the late avid triggers a 5-day right of rescission. The buyer's agent's avid does not trigger the right of rescission. The TDS is considered complete when it's signed by the seller and the listing agent. And if there's an avid, it's complete when the seller signs, listing agent signs the avid. When those are delivered and the buyer signs, the fact that the buyer's agent has not yet done their avid doesn't give the buyer any contractual or statutory rights of cancellation. That was a change to the TDS. That was a change to the TDS a few years ago. Some good questions here. That obviously this disclosure stuff has triggered a lot. What if the property, here's a very good question. The new HHDA fire hardening disclosure form is only required if the property is in a very high or high fire hazard severity zone. But this form can be provided, and I've already seen a lot of listing agents and sellers are providing this form, even if it's, say, in a moderate fire zone, or they even provide it just in general. If you provide the HHDA form, even though it's not actually required, does that give the buyer the 5-day right of rescission? The answer is no. It only triggers the right of rescission if it was given because it had to be given, and it only has to be given if the property's in a very high or high fire hazard zone and the property was built before 2010. So if this form is provided, trigger a right of rescission, and if you provide it, even though the property is not in a very high or high zone, it's only in a moderate zone or it's in no zone at all, right of rescission. Not, they'll accept as no, they don't. They really don't. No obligation to that. Sorry for the grayness about some of this escalation clause, but we've seen some court cases on some of these issues, but not on all of them. So I'm just advising you to advise your clients of the risk of doing it. Let me see here. Michael discuss seller broker advantage disclosure in the multiple. Not exactly precisely sure what you mean by that question, Michael, if you want to ask it a little differently about the seller broker advantage disclosure in the multiple. Let's see here. Let me keep going here. Questions. Yes, if you check the box in the TDS that references the AVID, then the AVID is part of the TDS. Can a buyer sign the disclosures and receipt for reports with their offer and agree to a seller counter that they waive the 5-day right of rescission? Well, Sue, if they sign the disclosures and the date of the signature of their disclosures is before the date of their signature on the offer, they don't need to waive their right of rescission because they simply don't have a right of rescission. But a good question related to that would be, what if the buyer doesn't sign the disclosures prior to signing the offer, but the seller asks them in a counteroffer to waive their 5-day right of rescission? That's a great question. Anytime you hear me say it's a great question, it's because I don't know the answer, because it hasn't been litigated. I mean, the law is very clear. Buyers cannot waive receipt of the statutory disclosures. Buyer can definitely not waive. You don't have to give me a TDS. You don't have to give me an NHD. Totally unenforceable. Does that mean they can't waive the right of rescission that is associated with those documents? That's the gray area. I'm inclined to say you probably can't. A court would say, well, you can't waive receipt of the disclosures. You can't waive the 5-day right of rescission, which means the only way to get rid of this 5-day right of rescission is to get them to sign the actual disclosure document. What can they sign? Something that says, I hereby acknowledge receipt of the TDS, the NHD, the lead paint, the NHD, TDS, HHDA, and the lead paint form? Or do they individually have to sign each one? Another gray area, hasn't been tested. On this one, I'm inclined to think if they just sign one document acknowledging that they've received the other documents and signing that, and the date of that signature is prior to the date of this or the time of the signature on the offer, that should be good enough. Hasn't been a case directly on that, but that is something to think about. Let me talk about something else. When you get multiple offers, right? It's a free country, right? Seller can accept whatever offer they want, right? Not so fast. Sellers cannot accept whatever offer they want if they're basing their decision on the buyer's personal characteristics. I mean, if you have two identical offers objectively, completely identical, the price, the down payment, the contingency period, let's say they're identical, and one is from a family with children and one is from a single person. The buyer says, I like families more than I like single people. I'm going to accept the offer from the family. Seller can't do that. You can't pick one offer over another offer based on the personal characteristics of the buyer. Not all personal characteristics. You know who you're allowed to discriminate against? Investors. I'm getting two offers. One's from someone who wants to live there, one from someone who doesn't want to live there. I can favor the one who wants to live there. But you cannot discriminate, as you know, on the 22 categories under California law you can't discriminate against. Not just the 7 federal categories: race, religion, color of skin, country of birth, age, gender, disability, but also 15 others. Can't discriminate on marital status, sexual orientation, family status, source of income, citizenship status, language status, immigration status, medical condition, criminal record, et cetera, et cetera. So sellers, that's why we have this form that's bundled with the listing contract and also bundled with the purchase contract, the Fair Housing Advisory, which tells everybody all these categories of people that you can't discriminate against, and to advise the seller that they shouldn't be thinking about that when they're deciding between offers. Which is why there's been there's something on the paragraph 8 of the Fair Housing Advisories as a little caution to people about these letters. I mean, if you're naturally, your inclination as a buyer, when you know you're competing with a bunch of other people, is to make your offer stand out. One way is to try to make it, the terms stand out. Another way is to include a personal letter of some kind, basically telling the seller how beautiful their house is. They've taken such great care of it. My husband and my 3 kids will totally love this property. My husband can open up his dental practice perfectly from this property. We just moved here from Indiana. It's a great place, blah, 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 blah. The problem with that letter is it's just told the seller the buyer's marital status, family status, source of income, where they're from, which are exactly the types of things that sellers shouldn't want to know. Because once the seller knows that stuff, there's the issue of bias. They can be accused later of, well, why didn't you accept that offer rather than this offer? Well, maybe it was because that offer, there was a family with kids, and that offer was a family without kids. It'd be easier if the seller could just say, I didn't know who had kids and who didn't. But once you get these letters, you do know, especially, and it's even worse when they accompany with photographs, which shows you the ethnic background of the buyers. That's another thing. It's no good for the seller to know that. I'm looking at it from a legal risk management perspective. Sellers could say, I understand all that, I still want the letters. Well, then it's up to the seller. Ideally, the listing agent and the seller has this conversation explaining the risks of this. And ideally, the seller says, hey, good point. Maybe I shouldn't want those letters. And then listing agent can put in the MLS, please don't submit letters, we're not going to read them, et cetera, et cetera. But I mean, if the buyer wants to submit the letter, they're going to submit it. And if the seller wants to read it, they're going to read it. Sometimes sellers want these letters, right? I mean, I got too many offers. I want to know more about these people. Well, they shouldn't want to know more about these people because that shouldn't be influencing their decision, both landlords and sellers under California law. Similarly, I get multiple offers and I want to counter multiple. Can I counter them differently? Can I counter this person's offer with different terms than this person's offer? Or do all my counters have to be identical? Goes back to what we're just saying. You can't give If you give different counters to different people based on the personal characteristics of the people, that could be a fair housing violation, right? So, and if you don't know who the people are, why would you give different? I mean, you can obviously give different counter offers based on the objective numbers in the offers, but don't, in other words, sellers don't have to counter everything identically. And they don't have to counter every offer. They get 20 offers. I'm not going to counter every single one. I'm going to counter 5 of them. Great. Why are you picking those 5? Is it the first 5? Is it the highest offer 5? It better not be based on some personal characteristic of these 5 buyers that you're choosing to counter. I mean, every buyer isn't, I mean, ultimately the seller can do what they want, limited by the fair housing laws, which is a serious limitation on what the seller can do, and it complicates your life here. Same thing, what if you have backup offers? What if you have multiple backup offers? Typically they're in order, right? Backup offer number 1, 2, 3. Typically you have to, unless you make it clear otherwise, in some counter offer, you're generally supposed to take the first backup offer in order. Of course, you don't have to allow anyone to go into a backup position. Can I allow some people to go into backup position and not others? Once again, yes, as long as it's not for fair housing related reasons, right? Yes, a good question following up. Even if the buyer removes the contingencies in the offer by checking that box in paragraph 14 and attaching the C.A.R. contingency removal, the buyer still has the 5-day right of rescission unless they have also signed the 4 disclosures that trigger the 5-day right of rescission. For the last 20 years, there were only 3 disclosures that triggered that: the TDS, the NHD, and the lead paint. There is now a 4th disclosure that triggers the right of rescission. That's the new home fire hardening disclosure. Sue, you're right. It's odd to sign disclosures before. I'm telling you, in the Bay Area, this has become a very common practice. They just automatically provide the disclosures up front. Buyers are used to it. Buyers understand in this market that if they don't acknowledge, they don't sign those disclosures before they sign the offer, they're not even get their offer considered. So yes, I know it seems weird and it's uncommon in Southern California at this point. Ruth Ann, good question. What if the decision is made based on what career the buyer has? In other words, I hate lawyers. I do not want to sell my house to a lawyer. I don't blame you. But yeah, unfortunately, that's considered discrimination based on source of income. So you can't discriminate based on someone's source of income, what profession they have, okay? Should I tell buyer's agents not to send letters? If you and your seller agree that that's the way to go, and I would advise that. What can you do? What can I do to distinguish? What if you do get identical offers? How do I decide, without breaking any laws, which one to take? You can't go wrong taking the first one, the one that comes in prior in time, because I doubt what if they were both signed at 3:57 p.m. on the same day? You're on your own, right? I mean, pick one. You'll probably be okay. Let's see. Getting back to disclosures. In case of multiple offers, some sellers' agents are not signing their rejection of offer. They just leave you hanging. Good question. So when a buyer gets an offer, as I said before, seller can either accept it, counter it, or reject it or ignore it. The seller has no obligation to reject. It would be nice if they did, but they really don't. As a listing agent, getting back to this whole theme of keeping everyone in the loop, being acting ethically towards your fellow agents, you try to persuade your seller. Don't leave them hanging. If you don't want to counter or accept their offer, be nice and reject it, but they don't have to ultimately. On the other hand, you all know this, ethically, the listing agent, upon request, is absolutely required to respond to the buyer and say to the buyer's agent, yes, I presented your offer at 5 o'clock on Thursday. Or the seller decided that they weren't going to look at any offers that came in after 5 o'clock on Thursday, or they weren't going to respond to any offers. They didn't want me to present any offers that were under 700,000. I mean, the seller can give the listing agent criteria, legal criteria, no lawyers, but don't show me offers that have any contingencies. Don't show me offers that are under 700,000. I mean, then they have to treat everyone the same. They say that, they got to mean that, and you have to follow through on that. But other than that, so bottom line is, when you're a buyer's agent and you request in writing after you submit an offer, what happened to my offer? The listing agent has an ethical obligation to say, I presented it and they didn't respond. I presented it and I'm waiting for a response. I didn't present it because the seller instructed me not to present any offers until Saturday, or I didn't present it because it was under 700,000. I mean, that's an ethical requirement to keep the buyer's agent in the loop of what's happening. It's not a legal requirement, unfortunately, for the seller to reject. Sellers can just ignore offers. Here's a very good question. Can I discriminate based on the buyer's lender? Well, generally, one of the terms of the offers is the type of financing, and it could even be the actual identity of the lender. Is that considered to be a legitimate basis? And it is. Sellers can discriminate against, they want all cash offers, and they only want conventional financing, no FHA. One little wrinkle on that is, be careful saying no VA offers, because that could be argued as discrimination based on someone's military or veteran status, which is definitely illegal under California law. But what about the lender itself? Seller says, I'm only going to accept offers if the buyers are using X lender. Buyers get outraged by this. I can use whatever lender I want. Well, no, actually the seller can, if it's not for a discriminating purpose or something, they can require a buyer to pre-qualify with a particular lender. They can even require a buyer to use a particular lender. It sounds outrageous, but if they're consistent, they don't make exceptions to that rule, the seller can do that. That's considered an objective part of the offer that the seller has the right to negotiate on that point. Very good question, Sue. Obviously, the last name or even the first name of the buyer often will indicate their ethnic background. No, I don't anticipate that there's going to come a time, I hope, where you actually have to withhold the name of the buyer, because by withholding the name, otherwise you're opening up potential bias. But who knows? Who knows what could happen? Right now, yes, there's absolutely nothing wrong with putting the name of the buyer, which would often indicate their refuse to present an offer that contains a buyer letter. In other words, not simply refuse to present the letter, refuse to present the offer. I don't want to see these types of offers or these types of offers. Always goes without saying, get the seller to put this in writing. You have this, protect, nothing verbal, you're gonna get in trouble. But if the seller gives you very specific instructions about what offers to present, what offers not to present, when to present them, et cetera, that's legal as long as there's no fair housing implication. And as long as you try to keep the other agents, the buyer's agents, updated on what the seller is doing, okay? Can I Mimi, can I issue a counter individually to one buyer and at the same time issue a multiple to two offers? So I got three offers. One I'm just going to give a regular counter to. The other two I'm going to give a multiple counter offer to. Understanding the problem with that is if you send a regular counter and the buyer accepts it and returns it, you have to accept that offer. In other words, you've accepted the offer. You don't have any wiggle room. So I'm not sure why a seller would want to do that. The question is, assuming the seller wants to do that for some reason, can they do that? Well, they're treating two buyers differently. Once again, just make sure there's not a fair housing reason why they're treating different buyers differently. Okay. Another very good question is, let's say the buyer's agent asks the listing agent, do you have any other offers yet? Does the listing agent have to answer that question? No. But if you do, you can say, I'm not going to tell you if I have any other offers or not. I mean, I'm assuming that's what the seller wants. If the seller doesn't say it, then you should ethically answer that question. But the seller could say, well, I'm going to keep this very close to the vest. I don't want you to disclose anything. In which case, do you have any other offers? I'm not going to tell you. On the other hand, if you do answer that question, as you probably should, hopefully, yes, I have other offers, you have to give a complete answer. Yes, I have 5 other offers and 2 of them are from my own buyer. You have to disclose if any of those offers are your offers, if you answer that question at all. I mean, this, like I said, if that's what the seller wants, you don't really even have to answer the question. But generally, you are going to answer that question, and you definitely have to disclose that if any of those offers are your buyers. Let's see, Ruth, going back to your question. Okay, Ruth, good question. Like, in other words, want to discriminate against a particular profession, you want to discriminate in favor of a particular profession. I would like first responders. So if I get multiple offers that are similar, I'm going to take the one from the first responder over somebody else. Unfortunately, that's discriminating against everybody else. And sounds sympathetic, understand the reasoning, but you're still discriminating based on someone's source of income, which you're not supposed to do. Yes, Marcia, if the 4 disclosures are signed prior to the offer, the 5-day right of rescission goes away completely. Karen, another great question. The buyers are doctors. Traditionally, medical doctors, their name, they don't say Mr. and Mrs., they say Dr. and Mr. or Dr. and Mrs. That's perfectly okay. That's understood. Yes, that's disclosing their the seller losing. Okay, I'm assuming that the backup buyer is actually paying more than the buyer that they're bribing to back out. In which case, if that happens, how is the seller injured? But you're right, you can't interfere with a contractual relationship that someone already has in certain circumstances without being liable for a lawsuit. So is offering money to the first buyer to get out of the deal, theoretically, that's possible that could be considered interference with contract, depending on what results from that. So maybe that's something to be careful about, right? Um, can you discriminate against the buyer based on what they've indicated, what they're going to use the property for? In other words, the example someone gives me is, yeah, this is a property that's great for growing for my marijuana farm. This is a wonderful property for that. Thanks for selling me this marijuana farm property. And the seller's reaction is, I don't like that. Can I use that? Well, I don't think that's a protected class, because that's not their source of income. That's just their intention of what to do with the property. Of course, the buyer probably shouldn't have disclosed that, but once they did, I don't think that's necessarily a protected class. But what if they say, yes, my current sole source of income is selling marijuana. This is a great property to add to my portfolio. Well, assuming they're acting legally in their current marijuana selling business, arguably then we're getting to, well, are you discriminating based on their source of income, their current source of income? By the way, what about criminal record? Can I refuse to sell to anyone with a criminal record? Not so fast. You have to, it depends. In other words, you have to look at what type of crime it was, how serious was it, and how long ago did it occur? Typically, if it occurred more than 7 years ago, it wasn't a felony and it didn't involve any fraud or violence or anything like that, that's not supposed to be, believe it or not, a criteria as to determine whether you're going to accept that particular offer. Randy's asking me a question about the new RPA. Randy, I refuse to ask questions about the new RPA. That's my policy, because it's still not finalized. So until it's finalized, I'm not talking about it. I'm going to talk in August, September, October, November. This is all I'm going to be talking about. So I'm going to save that for them, because remember, you don't all know, training will be a lot. Statement from the sellers as to their instructions relating. How long does the agent? Well, your first. Provide to this buyer's agent. Sellers would actually leave money on the table just to favor people from their area. Never occurred to me that sellers would do that, but I think that's okay. As long as you're not discriminating against like buyers from foreign countries, right? Then you're discrimination based on the country of origin. But if you're just favoring people from Santa Barbara, from people from Nevada or something, I don't think that's a protected class if the seller wants to do that. You're seeing sight unseen offers and sellers are rejecting those. Elizabeth, I'm not sure exactly what you mean. I mean, in other words, the seller has absolutely no idea what's in the offer. They just don't want to see it. I wonder why that would be. Maybe you can elaborate exactly what you mean by that, because I'm not sure I understand. I think we're running out of time here. I think I've covered the questions, and I've pretty much covered what I wanted to talk about. Last thing to mention that we're seeing over and over on the hotline now, sellers trying to cancel offers they've already accepted because they realize they can now get more money for it. Hello, seller, you have no right to do that. Or they say, well, I'm sorry, I can't complete the sale because I can't find a replacement property. Well, too bad for you. You should have countered the offer with the SPRP, the seller purchase of replacement property, saying, I am accepting your offer contingent on me finding a replacement property. So if you don't do that, sellers can't just get out of a deal because they haven't found a replacement or because the market has changed and they can now get more money. Now, thank you, Randy and Marie Sue, for pointing out that question. In other words, offers from buyers who have not even seen the property themselves. So the question is that a real offer? Yeah, that's a real offer. And the seller can accept it. I guess what you're saying is, maybe what you're saying is sellers are rejecting offers because the buyer hasn't seen it. In other words, they're only comfortable accepting offers from buyers who've actually been into the property. I'm thinking in the back of my mind, the seller's thinking might be, well, this buyer who's never even seen the property, once they do see the property, they're going to think that they're going to find problems that they think the seller was hiding. And that's, I'm going to be, in other words, I'm more likely to be sued by a buyer who never entered the property before they made their offer rather than a buyer who did. So can I discriminate in that manner? And I say yes. That's not a protected class, buyers who have not entered the property. So yes, you can discriminate against buyers who haven't seen the property in favor of buyers who have seen the property. So yes, there are still people you can discriminate against in California. Just that there's so many people you can't discriminate against in California that everyone needs to keep that in your mind. And that's why we have that form. What are the best practices when a team member wants to write on the team leader's listing? Well, obviously, the seller has to be aware that this offer is coming from basically the agent who's representing them. And that's perfectly okay. And of course, any buyer's agent who asks, do you have any other offers? You'd have to, and you're going to answer that question, you'd have to disclose, yeah, we have an offer from, one of the offers is from the actual member of the team that is the listing agent. It has to be disclosed, in other words. It's perfectly legal, but it has to be disclosed. Okay, I'll stay as long as you want, but I think we've hit an hour. And I'm not seeing any more questions.
Okay. All right. Thank you so much, Gov. This was a real treasure of a keynote presentation, and hopefully everybody took good notes. And this is being recorded, and so it's possible to go through it again, and it would probably be good for us to go through it again because there's a lot of information there. But it's I think it's going to make things a lot smoother in the future for multiple offer situations.
Thank you, Richard. Let me just say a general comment to everybody. Stay tuned. The state is going to be opening gradually. Yes, your wishes are going to be answered. At some point, you're going to be able to do open houses and not follow all these rules. We're in talks with the governor about this. We don't know when things are going to change or how, if it's going to be radical change, gradual change. Just stay tuned. Change is coming. You've been dealing with change for the last 12 months. You're going to deal with change for the next few months also. Stay in there, keep going to meetings like this. Read the emails you get from C.A.R. because we will update you every time something happens. And with that, I'm going to say sayonara. See you
Gov,
next time.
thank you very much, Gov. And I just want to thank all the members who asked the questions. I mean, it was a great group of questions. I can't believe how many times you said, very good question or great question.
They were good questions.
They were good questions, great answers. We are so blessed to have the legal hotline when we need it. And so thank you very much, Gov, for your presentation today. And I'm sure all of us need to see this thing 3 or 4 times through because it was so full of information. We can't absorb it all at once. But thank you again.
And I will leave if you want to talk about things without an attorney being present. So I will leave right now. So bye, everyone.